Thank you, everyone. Please be seated. And Jenna, could I have a roll call, please?
I'm trying to turn this on and see if it's gonna do the same.
Okay.
Okay. Trustee Stout.
Here.
Trustee Rhodey.
Here.
Trustee Belt. Here. Trustee Kreiser. Here. Trustee Grabowski.
Here.
President Knutson.
Here.
And Trustee Pater is excused.
Okay. What we're gonna do, since we're gonna go right into a new business, and we're gonna go to 2B, hearing on an appeal of the 2024 Fire EMS Protection Field filed by JM 1405 LLC CO Kevin Yankee regarding real property located at 205 Prospect Avenue, Yankee and Son Funeral Home, and having tax ID number PWV 0896069 and possible action thereon. Matt, you want to start us out, or?
I guess I'll start it off, I guess since I'm the only one, or one of the only ones that has institutional knowledge on how we did this last year. So for the members of the board that weren't on the board last year at this time, well, as residents, you're generally aware that the village has implemented a fire and EMS fee to recoup its costs and to fund its services for fire and EMS. It's an annual fee that is charged on the property tax bills for properties in the village. And the methodology used to assess that fee is based on what's defined in the code as emergency service equivalents. And that's the base amount used to calculate the amount of fees charged to each single family property, regardless of size or value. And the methodology using the ESCs is set forth in the code, and it's assessed on an annual basis. But as part of the ordinance that the village enacted, property owners have the ability to appeal the determination of ESCs assigned to their property, and by extension, the amount of the fee that's assigned to their property. And that appeal process occurs with the filing of a petition with the village clerk that is first reviewed by the administrator to make sure that there were no errors in determining either the amount of ESCs assigned to a property or the amount of fee charged to the property. Once that determination is made, the administrator communicates that to the property owner in writing. And then once that is received, the property owner can further appeal that determination to the village board. The ordinance provides first for a recommendation from Public Works and Safety, and then action by the board. Some applicants in the past, and the village has agreed as well, to waive the Public Works and Safety Committee process and proceed directly to the board. And that's what this applicant, Mr. Yankee, has done. So at the board level, your role tonight is to conduct the hearing in accordance with the procedures set forth in the ordinance. And in conducting that hearing, your determination is this, and this comes directly from the code. This is what you have to focus on as you receive evidence, and I'll go through what that process looks like as well. But the board shall determine whether the number of ESCs assigned is fair and reasonable in accordance with the terms of this ordinance. And in the event an appeal is granted, whether or not a refund is due the appellant and the amount of such refund. In conducting the hearing, how we do this is the board obviously sits in like I said, a quasi-judicial role. So really you're on fact-finding in taking evidence presented by the appellant and by the village in the form of the administrators. So procedurally what will occur is the appellant will have an opportunity to present to the board whatever information he may wish. The board can ask questions of the appellant if they wish, but we should give the appellant an opportunity to make the presentation as he sees fit. After the conclusion of whatever evidence the appellant wants to put on, the village administrator will give a presentation on behalf of the village as to the fee that was assessed and how that determination was made. Once those respective presentations are made, the evidence will be considered closed. The board will then deliberate based upon the evidence that was presented to it and make a decision to either uphold the fee that was assessed or to grant the appeal. In the event an appeal is granted, there should also be some action on what refund, if any, should be owed to the appellant. And how that works procedurally is the action would be taken tonight via a motion, assuming the board wants to or has enough information to move forward. And if action is taken tonight, a written decision would be presented codifying what the action that was taken tonight at a later meeting. So with that, that's kind of the procedure and what we're looking at. Any questions from board members before we hear from the first appellant?
Could you say that one more time again, the number of EFCs assigned
Sure.
statement?
Sure. So, and it's a good question because it's really the central what the board is looking at. So, the board shall determine whether the number of ESEs assigned is fair and reasonable in accordance with the terms of this ordinance. So that's the main determination and what the appeal, the decision of whether to grant or deny the appeal is made.
Truly in accordance to the ordinance.
Correct. So there's, yep.
Are there any questions or comments? Would, Mr. Yaki, would you like to address the board? The board okay with that?
Well, so the appellant does have the right to make it, so it's really not up to the board. The appellant does have the right to make his presentation. So if you could identify yourself, sir, by name and address, please.
Kevin Yaki, 205 Prospect Avenue, Pewaukee, Wisconsin.
Thank you, sir. What information would you like to present in support of your appeal?
Well, I understand your whole, how you arrived at the number. I discussed it, with Cassie previously. I'm going with just comparisons. At the funeral home, I have a building appraised at approximately $650,000, and I'm paying roughly $2,200 in EMS fees. Now let's take a property on Hickory Street, 10.5 acres, appraised at $4.25 million, and it's got probably close to 300,000 square foot building on it, and they pay $2,600 in EMS fees. So that's the disparity that I see. I'm using value. We have lake homes in excess of, $2-3 million in our community. They pay, I believe, $489, I believe, don't hold me to that number, per ESU. And that's what they pay for EMS. We have another building in the community, appraised at just shy of $1 million. Numerous businesses within that building, also apartments, that pays, I believe, $1,700 in EMS. My question is, just because I have a larger building, which is a funeral home, very limited use. We're not retail. We don't have people coming and going every day. With the advent of COVID, the funeral industry per se has changed drastically, and the number of traditional funerals. So the use of that funeral home has decreased drastically, which doesn't affect any of this, but I'm just saying we're not a high use. We are not, every day having people in and out of the building. And we've been here, I believe, 68 years. We've had 2 EMS calls at our facility. And those were no fault of ours, but grievers, alcohol-related incidents. So we've never had a fire call at our facility. So we're not really relying, we need the EMS. I'm fortunate to have such good EMS and fire protection, but we're not really a high use or a high risk entity. We have a funeral home, chapel, garage for hearse, and et cetera, a residence above, and that's pretty much it. And I feel at $2,200, is kind of exorbitant. I thought, you know, like, prime example, the tavern right next door here is charged 2 units, one for the business and one for the apartment above. And that's kind of all I can say here. I don't know how else. If anybody has any questions, I'd feel free to ask them, but that's kind of what, I was just using comparisons. And the one prime is, you know, on Hickory Street, you know, they're storing boats, gasoline, cars in and out of there, people, etc. And they pay $400 more than I do. Well, thank you very much for hearing me.
So, Mr. Yankee, just one question. Do you have a position on so obviously you're challenging the fee that you've been assessed.
Yep.
Do you have a position on what fee you believe you should be assessed under the ordinance?
Well, I would think, you know, one for the business, like a majority of the businesses in the community, and one for the resident.
So when you say one for the business, you're treating the business portion of your property as 1 unit,
Correct.
and then the residential is 1 unit.
Correct, yes.
Thank you for the clarification.
It's kind of the same thing that they used at, you know, numerous businesses within our community that have a business on the lower and a rental or apartment above.
Okay, our ordinance the appeal requires the appellants to have a position or set forth a position to the board as what they feel would be fair under the ordinance, so just want to clarify.
Thank you
that.
for asking.
All right.
Are there any other questions or comments?
So is that true that other properties that are split commercial and residential, we split that's split in the ordinance, or how the fee is assessed, that is a separate business classification and a separate residential classification?
So
I didn't think,
it's not,
Okay.
just for clarification purposes, and we'll let the administrator make his determination, which I think is going to actually answer part of that question. But the ESE and the property classifications are defined in the code, and for commercial, the term commercial is defined in the ordinance as properties zoned B1 community, B2 downtown, B3 and service district, and B4 business park. So really the definition of property classifications as set forth in the ordinance is based on zoning. Now, there could be a situation where some properties have mixed zoning. In that case, there may, and I don't know if this exists in the village, but there may be a breakdown in units along what you're saying. But I believe Mr. Yankee's property, and I don't want to step on the administrator's toes, but I believe it's zoned B2 downtown entirely, which is why it was assessed as a commercial property. But again, Mr. Yankee, do you have any other evidence or witnesses you'd like to present this evening? You're looking at it. All right, thank you, sir. Then we'll consider the appellant's portion of the presentation closed, and I'll look for the village administrator to present on behalf of the village.
Thank you, Attorney Grulinski. JM 1405 LLC, owners of Yankee and Son Funeral Home, filed an appeal for the 2024 fire and EMS fees on January 8th, 2025. The property is physically located at 205 Prospect Avenue, which you heard Mr. Yankee say. And just for the purposes of the record of this hearing, the tax ID number for the parcel is PWV 0896069. The property is zoned as B2, or the Downtown Business District. The ordinance, the fire and EMS fee ordinance, classifies this property as a commercial property, and the village records have the building square footage at 15,520 square feet. The fire and EMS fee ordinance charges that classification 1 ESE for every 3,350 square feet of space in commercial buildings. So if you take that total number of the space of Mr. Yankee's building, the 15,520, and you divide that by the 3,350 that's in each ESE, you get a total of 4.63 ESEs for that building. The ordinance does not provide for a fractional ESE. So the methodology of the village is to round up to a total of 5 ESEs for that building. In 2024, the village charged the property 5 ESEs at $439 per, for a grand total of $2,195. When Mr. Yankee filed his appeal, village staff confirmed that this arithmetic was correct.
Do we know how many square feet there is residential versus the actual business?
We do not. And our ordinance doesn't really provide for breaking that up. If it's zoned B2, it's considered a commercial property, and it's, the fee is calculated based on 1 ESC per 3,350 square feet, regardless of the breakdown.
So does that mean properties such as Beachscape, I'm just trying to think other mixed use that's retail, residential, is that applied the same, that they took the total square footage of all condos plus the total square footage of all retail?
Yes. That's correct.
And then they divided it by the residential owners and then the commercial use owners?
No. The village determines a total fee for the property, regardless of how many commercial units are within that structure. The only time the village talks about, or the ordinance talks about individual residential units are on properties that have multifamily or different cares, and those are zoned differently. So for commercially, for property that's classified as commercial, it's applied the same way across the village. It's total square feet divided by 3,350.
So I mean, obviously I'm assuming using that one building downtown as an example, then it would be on the property owner to divvy it up as they see fit.
Right.
Which then begs the question, does the ordinance need clarification on that? Because obviously those residents make up the lion's share, but yet they're zoned commercial. Or lion's share of square footage. So then is there any validity to the comp that was given of the business on Hickory? If we're going off of square footage, why were they charged less?
I'd have to, I'm not familiar with the comparable that Mr. Yankee used.
You want the address?
Yes, please.
1045 Hickory, Stowe, Cooper Power, ED.
And is it the rate different by the zone? So zoning downtown would have a higher rate versus, or is it all?
No, so the zoning, forgive me for a moment. So commercial includes property in B1, B2, B3, and B4. So not all of that's in the downtown. Obviously B2 is, there's not a higher rate per se if you're downtown as to other locations in the village.
Okay.
So I'm looking at the tax bill for 1045 Hickory Street, and it looks like the village did indeed charge $2,634 in fire and EMS fees.
And is it accurate with the assessed value of 4.25?
Well, remember, this is not an assessed value. This is.
I know, I'm just saying, I'm just validating number, the check would verify with the information given. I get that we're going off of zoning and square footage.
Yeah, so,
Would it list the square footage on there?
well, the tax bill doesn't list the square footage. So I would have to go into the village worksheet to see how we did our calculations for that property. But I think Mr. Yankee was accurate with his report of the assessed value of $4,252,800.
Look at the property on the plat map, that's approximately 10 acres, and the building covers roughly half of it, and an acre is 4,300 square feet, so I guess
Do you know how big your apartment above the funeral home is?
Probably 1,800 square feet to 2,000. Garage would be 1,000.
And
And then the attic, if we had that, that's finished, probably closer to 2,500 with the attic. You know, there's actually 3 levels up above the funeral home.
I just wondered, when we did this, when we're looking at commercial, if the building has a basement, is that also considered part of the square footage or not?
I believe so.
There's nothing in the ordinance to suggest that it would not be.
Yeah.
Are the rates different for commercial and residential?
Well, they're calculated differently, okay?
Okay.
So what we do is we have the total amount of money that we owe the city of Pewaukee for fire and EMS service. And then we divide that by the number of residential units in the village to come up with a base ESC,
Okay.
value of 1. All single-family homes get a value of 1. Multifamily structures get 1 per residential unit. So if you have 100 units in your building, you get a charge for 100 ESCs.
Okay.
And then commercial and industrial and institutional buildings are calculated using square footage because they don't have anybody living there, right? So we can't charge per residence. There's nobody living on those properties. So we do it based on size. So you get an ESC per 3350.
Was this perfect? No. However, in this specific situation, my first inkling would be to subtract out the residential and, apply it almost like dually. However, the situation we run to here with the square footage you gave, it's basically a wash because we would be, using for easy math, your upstairs is 3,350 square feet, which you were trying to get up there. So that would take 1 ESC away from your assessed, and then it would give you 1 ESC residential, 4 ESCs for the commercial. So it would be the same. Basically, we're robbing from Peter to pay Paul. Yeah, so that's the problem I'm running into of, was it calculated out correctly? I think by the letter of the ordinance, it was. Is there an imperfect science there? Possibly. And it's something that I think maybe we should look into now that, as a board down the road of those anomalies that are in the village. Like I said, I just don't know where we're going to be able to come up with something that would be beneficial. When we start breaking
Before we get too much into the deliberation on a potential decision, does the administrator have any other information to present to the board?
I do not. That was my presentation.
Do board members, based on the information given, do any trustees have any specific questions for the administrator?
Can you figure out the square footage of that one property, Mr. Yonke? Is there a way to, was that an error on our end? Or is it just a small building with a lot of acreage?
I'm looking for it right now.
After EMS went down this year from last year.
And how did you find this information?
Go right on GSI, which are calling.
But I guess that doesn't change what we have to do here, because we just have to rule on if it's applied to Mr. Yonke correctly, not if it was incorrectly applied to another property.
So are we in the deliberations phase now?
Did we move phases?
Unless the trustees have any questions for the administrator. And before I guess we move to that, I just want to confirm with Mr. Yonke, besides the presentation you made this evening, sir, you submitted a letter to the village dated January 14th, 2025, is that correct?
Yes, pretty much what I have said.
Okay. Yes, So we'll make sure that that's part of the record. And on the administrator's part, sir, you submitted a response letter to Mr. Yankee dated February 5th, 2025.
That's correct. Yeah.
We'll make sure that's part of the record as well. So with the presentations on behalf of the appellant and the village closed, I think the board is in a position to move to deliberation and potential action.
Trustee Rhodey.
Raise your hand higher.
You know, when we envisioned, when we put together this ordinance for the fire EMS fee, we knew at that point we could not take into account every outlier or unique situation that there was out there. You know, so we covered where we felt we could and put into place the appeal ability to look into this. Now, when I look at the calculations, quite honestly, it was calculated correctly according to the ordinance. But I think what I look at is this fair and reasonable in our approach in Mr. Yankee's case? And that I have problems with. Okay, first of all, the funeral home is used, I believe according to your letter, about 20 times a year. That doesn't necessarily qualify it for reduction, but it is essentially a home above a home. And I feel the rate that we are charging him in comparison to other facilities that have a lot of activity, that have a huge amount of customers, whether it be a retailer, restaurants, wherever, for him to be charged at that rate is not fair and reasonable. I think what he is proposing actually of the two ESEs is reasonable and fair, and that's what I would suggest going with for the board for this very unique and outlier type case.
The proposal was to ESEs?
What he, Mr. Yankee was suggesting was the two ESEs.
No, you're saying 2 units or dividing them to apply 2 different versions of
He
it?
said the 878, right, is what you're referring to?
He was actually,
Yeah.
yeah.
Okay, I was just clarifying. Okay.
Yeah, I think his position when I asked for clarification was essentially treat residents 1 unit, commercial 1 unit. Assign 1 ESC to each.
But the commercial piece should still be based on square footage, not just one ESC.
If it was
If
treated
we're
as
kind of, if we're
commercial.
following,
See,
How many,
Oh, sorry, go ahead.
may I ask, how many square feet did you say is the funeral home itself-ish?
That chapel's about 2,500 square feet.
Because I'm gonna say, when we subtract out the residential, I don't know if there's any way to get to 12,000 square feet of that.
Figure, Jim, you're spot on.
I mean, I walk past it all the time. It doesn't take you that long to get around it.
Yeah, I was shocked at the size.
Yeah,
It looks like a house.
15,000
Yeah.
threw me.
But the 878, is that just considering it as 2 residential?
Basically.
Essentially, yes.
Yes.
So you're not taking into square footage in that.
If I may ask, what is it called, not particularly, whatever, Four Keeps, isn't it? That's considered 2 units, and that's a tavern on the bottom and an apartment on the low. I don't know how, that's kind of where I came up with the 2 units. I don't know what that building is considered, commercial or.
Well, yeah, if it's considered commercial, it wouldn't matter. It would just be square footage.
So it must be 6,600 square feet or less.
Yeah.
Yeah.
Yeah, right. It would just be square footage. And if I could just clarify, based on that other comparable, there's a different rate for land that's classified as industrial rather than commercial. So per the ordinance, if you are classified as an industrial property, which I think the 1045 Hickory would be, it is 1 ESC for every 31,000 square feet.
But and this is a matter for another time, is it classified correctly?
Yes.
Industrial prior, it would have made sense, but for what it's being used right now. When it was Cooper Power, it was industrial. But is it industrial now?
So industrial is defined in the Fire and EMS Code, Chapter 93, is property zone B5 light industrial. So it's tied again to the zoning. So I'm guessing that parcel is still B5.
Unless they've rezoned it.
Oh, getting back to Yonke again then, would the basement actually be considered part of the residence then, and not that square footage would not be part of the business? I mean, is that also possible?
Is the basement finished and livable? Then I don't, I mean, in residence, it's not considered square footage if it's unfinished and, or typically, I don't know how the state of Wisconsin, if they classify it as not, but if you don't have an egress or a finished basement, I don't believe it's counted as square footage. So, like I said, I would struggle to find 13,000 square feet, you know, once you eliminate out the apartment upstairs. And the apartment is basically the same, for the most part, the bulk size of the building, matching it with the exception of the, like I said, the chapel and such. So I can't figure 13 or 12,500 or whatever of commercial space. Agree with Trustee Rhodey. Is it applied as the letter, as it's written? Yes. Is it fair and reasonable? I don't believe so as well. I mean, we knew we were gonna run into outliers like this, and, I mean, if you look at it, up until, 5 years ago, I was sitting on the Plan Commission, they tried to rezone my house to B2, because I'm close enough to the downtown. Like, yeah, we went through every zone, Bob, you know, sitting on the Plan Commission as well, we go through every one of these, and we went through every parcel, and, I mean, there's ones that are over there on Oakton that are technically commercial and are residential houses if they ever get occupied again. You know, we do have these outliers that we will have to address. So the fact that we will have to address these in the future, I mean, we might as well start now.
Can I clarify, Administrator, that if it was two ESCs for residential, is that the 439 per?
What does one ESC cost?
One ESC is 439.
It's 439,
Is
okay.
one ESC.
And that's for residential, or for regardless?
Right, that's, right, one ESC is
Is
one
one ESC.
across the village.
Yeah.
And just to kind of make it clear, so if it's a residential unit gets charged one ESC.
Single dwelling.
Single family or multifamily, one residential unit is charged one ESC. And if it's not residential, if people aren't living there, then the ordinance charges by size. And there are different rates depending if it's commercial, industrial, or institutional.
So it seems like we're not clear that the square footage is accurate for the property. Can we get an accurate square footage? If that's the issue here, if there's an error in the calculation because of the square footage, to me, it was calculated correctly based on the ordinance, based on the information that we have. If the square footage is incorrect and that was calculated incorrectly, then I could see us adjusting it. So how do we determine how do we validate that square footage?
Because this amount would be,
Into Trustee Gabrowski's
If,
methodology there?
Yeah, I mean, that would be if the square footage of the funeral home was accurate, which,
Correct.
getting back to Trustee Bell, we don't have. We, you know, because like I said, if
But
we
if-
take out the 3,300 for the residential, or the upstairs, and make that one ESC, that's just a wash. So there's, I mean, this is just an exercise in futility then.
That's as long as the basement is not being
Exactly,
included.
but if the basement's counted in and whatever else, like let's say that the funeral home comes back at 6,500 actually of just the one level, then it does make a difference financially.
Right.
because we're at, right now with your, what is in your assessed value of the 2195, saying it's 16,750 square feet, correct?
Well, we're saying 15,520,
And then we round up.
and then it's.
Then you round up.
It's rounded up, right, because that
Correct.
comes, right,
Correct, yes.
yes, but your thought process is
Yes.
correct.
So in this specific case, kind of going back to your comment, trustee Rhodey, the appeal gives the opportunity to kind of explain what the commercial use space would be. And I think we would maybe have to discuss and determine the square footage for commercial usage. I think that'll be a fair way
So
to go.
first floor, strictly first floor.
Well, yeah, I mean, I'm assuming the chapel's not commercial usage, the basement. I mean, we could go, and what is actually used for funeral home services within your property? And we could probably get that down to a reasonable size and do the square footage and then do the one ESC for the residential property.
So really, what's not being used as commercial space, though, is just the apartment upstairs.
And the basement.
First floor, but no, he said his workshop, his.
It's my personal.
Oh, personal.
Personal.
Built cabinets.
Oh, I'm sorry, okay,
Has nothing to do. with
okay.
motorcycle.
I misunderstood that then. But,
So yeah, I mean, I don't really know how I could come to an actual final conclusion until we have numbers of actual square footage, because that's gonna determine if there is any benefit to adjusting or how to adjust.
but then there is the question, is the basement a separate residential unit, 'cause it's not rented, it's not used by they're not leasing that out to the resident upstairs.
But I'm saying,
So is that
I mean, if
considered
it's not an actual egress habitable, whatever,
Correct.
you know, then that wouldn't be counted in.
Well, it's part of the residential unit.
Part of the ratio, yeah.
Oh, yeah, it'd be part of the one, I guess. Yep.
And then
What's the rate for churches and for religious centers?
1 ESC per 6,500 square feet.
And unfortunately, there's no fraction, so if you go off of that, then the chapel. would be
Chapel
one.
is one automatically.
I think what we need to do here, ladies and gentlemen, is, it was already stated, that we need to get to know how many square feet upstairs, the second level, which is the main funeral home, and his workshop, the basement. Because I guess if you're looking at it from the standpoint of most homes in Pewaukee have an upstairs and a basement. And they're charged 1 SE, but they're residential. So if you combine the two units, the basement and the upstairs, as being residential and the center as being the commercial part, that is what we should be looking at as far as a commercial. But without knowing exactly what those numbers are, I think right now we're in a matter of, we're going nowhere.
Just to clarify, basically, all we need is the square footage of the funeral home, because everything else is one. I mean,
Okay,
it's
then that
not,
would be
yeah,
a-
square footage doesn't matter on that.
I want the square footage of the entire building. I would still like to know that, because, I mean, honestly, based on our ordinance and based on the zoning,
Be nice.
his fee might just automatically come down if the square footage is even incorrect. So I think we need to have all the information, the square footage for the entire building, and divide it out. I think it's important to have that too.
That's a good point. If we decide, if we can't alter and do a split, then
Right.
you're right, it might be calculated incorrectly. You're right.
Would that open a can of worms for like Beachscape? I mean, it would be on to them to appeal, and then we would
on
go
to them.
case by case, right?
Yep.
Okay.
That's,
And we're past.
Well, I'm saying for next year.
We're past the
and then-
appeal period.
we're past the appeal, but anything you do here, serves as a precedent for future, so.
Right.
I understand the tact the board wants to take in looking at square footage. The only comment I would have is that's not how the ordinance reads, but it does give you the opportunity to, as trustee Rhodey said at the outset, look at what's fair and reasonable in accordance with the terms. So I think you can base a decision on that using this appeal process, but the board should be aware it is outside of what you've set forth in this methodology.
So the motion that I think we may be looking for is to defer this to a different hearing and have the staff.
I guess that's the question for me. Who are we relying on to provide corrected information as to the square footage? Is this a matter
Do you
of
have a
looking-
recent survey? Like with
I
a,
think about 15 or so years ago when I refinanced.
with a platted dwelling on, with the buildings platted on there?
I don't know if I can find it, but it had all the square footage of the building on it.
I mean, Matt, are we able to basically defer, pending new information, and if nothing is able to be provided, then we have to rule?
I'd say motion to continue the hearing to a date certain. And then
I'm sorry, repeat that again?
motion to continue the hearing to a date certain. Don't make it the next meeting, but give some additional time for the appellant to do his due diligence. And it's not to say the village can't review its own records and make sure that the square footage we used for the fire and EMS calculation is correct. You can look at whatever building permits we may have on file and such. But then, rather than having some sort of nebulous further information, because this is a quasi judicial hearing, I'd rather have it a date certain in 45, 60 days.
I'm trying to think, you presented for a new garage about 5 or 6 years ago. And I think you included a survey in that packet, if I'm not mistaken, with the application.
No, it wasn't a survey of the property, it was a survey of the neighbor, and it showed the lot line that was affecting, which we didn't encroach upon.
Right, okay.
We just needed the one.
I just remember you submitting for it. I was gonna say, go back in your files 6 years ago.
Yeah, we didn't have a survey, the last survey on that property was probably about, 1990, 91.
And nothing has changed on.
Yeah, I wouldn't even, I can't find my social security card, so to find that, it'd be, you're like a chipmunk looking for a lost peanut.
If you remember who your surveyor it was, then they might be able to assist you.
I'm looking now, I got my card, I wouldn't even know, to be honest with you.
I'm looking for a motion stating, as the attorney pointed out, a date.
Are we able to do this in a scheduled meeting, seeing as that we've already had the presentation, discovery, every other element, and it's basically just asking for one piece of information and a ruling?
I would find it reasonable that you could put this on a regular agenda.
Okay.
I don't think it's gonna gum up the works too much. So looking at, let's see here. 45 days would take you to about the July 15th meeting. So that would probably be the earliest that I would schedule it, if you're asking me.
So that would be at the regular village board meeting.
And I guess since the appellant is here, sir, are you available to reappear on July 15th in front of this board? All right. Are you clear on what the board is requesting in terms of additional information from you, sir?
A footprint of the building.
Well, square footage. Yeah.
We can work off the footprint, of this lot, the square footage just measuring outside of the building.
Okay.
Can we try to break it up just for our clarity for the upstairs and the funeral home? Thank you.
Well, who's gonna be providing that information?
I can draw a map, and if you want, we can come with a laser, you can.
Well, In specific environments, they're called as-built drawings. And sure. So you could potentially hire a firm to come in.
In 1968, that put an addition on, that was the back chapel, approximately 2,500 square feet. And then in 1993 or 4, I put an addition on the front of the building.
Right.
You know, so, but there is no, I might be able to find some blueprints of 93 edition.
So what I would say is, I think the board has clearly said what information they want. It's up to the applicants to provide whatever information he thinks is responsive, and then the board can weigh at the next meeting whether what he provides is credible enough, I guess, as in your
So
role.
that'll be on the 15th of July.
I'll make a motion to defer to July 15th meeting.
Continue the hearing to July 15th.
Gonna rephrase that. I'm gonna make a motion to continue the hearing July 15th meeting.
Second, Rhodey.
All in favor, say aye. Aye. Opposed? Okay, motion is hereby carried.
Thank you, sir.
I almost said I too.
Old habits die hard.
Force of habit, eh?
Quickly chat with them.
Okay, new business, hearing on appeal of the 2024 Fire EMS Protection Fee filed by Hawthorne Place LLC CEO Michael Heisey regarding real property located at 1105 Hawthorne Place and having tax ID number PWV 09029960007 and possible action thereon. Again,
I'll look to the administrator just to update on the recent contact he had with this applicant, and then if the board will permit, I'll just make a brief record as to what's occurred previously.
I received a call from Mr. Heisey stating that he had just learned of the hearing a couple of days ago, and that he wouldn't be able to attend tonight. And I told him at that time that I would double check with the attorney and get back to him. When I got back to him, I left a voicemail saying that the board had scheduled the hearing, so staff doesn't have the authority to reschedule or undo that. That would be up to the board if they wanted to schedule another one. I did remind him that he already did have one courtesy adjournment already in my voicemail message, and then I did ask him to get back to me with his availability, knowing that we would be discussing it tonight, and he did not provide that for me.
Just for clarification, when did he, or who reached out to you in this recent contact?
Mr. Heisey himself.
And you reached out via telephone?
Correct.
On what date?
It was May 30th, Friday.
And your return voicemail to him, was it the same day or a different
It
day?
was the same day.
All right, so May 30th. And did you provide Mr. Heisey notice of today's hearing?
I did. So I sent it certified mail on May 21st.
You mailed it May 21st. Did you sign it with a return receipt requested?
He did, but it was much later than that. It was, boy, do you want me to go back to my office and check to see what it
Do
says?
you have a copy of the return receipt?
I do. It's in my office, though.
If you can grab that, and I'll make a record just for the,
Okay.
for the board as to what's occurred, and we'll put that on the record. So, really, the reason I'm doing this is the board has two choices as to what it can do. So, at the conclusion of my summary of the record, what I would look for is either a motion to proceed with the hearing on the appeal this evening, or if the board is so inclined, a motion to adjourn the hearing to a different date. As we've already gone over, what our code requires is that the board conduct a hearing and provide notice to the appellant at least 5 business days prior to the date of the hearing. The applicant shall be afforded the opportunity to be heard and present evidence in support of their appeal. With respect to this appeal from Hawthorne Place LLC, care of Michael Heisey, The appeal was initiated with the clerk of the village by a letter from Mr. Heisey dated January 13th, 2025. The appellants provided their intent to proceed to this board for a hearing by notice hand-delivered to the administrator on March 6, 2025. The village administrator sent a courtesy letter to the applicant dated March 20th, 2025, laying out an expected timeline at that time with an anticipated hearing date of potentially in early May. Scheduling of the appeal hearing was first discussed in open session of this board on April 15th. At that time, the board scheduled a hearing for May 6th. With that hearing, there was a notice issue on the village's end, whereby the May 6th hearing did not occur. And actually, scheduling was again discussed in open session on that date, and a hearing scheduled on May 20th. The appellant was provided notice properly at that time for the May 20th hearing by letter dated and mailed on May 7th. The village administrator was notified on May 19th that the appellant was out of town and could not make the May 20th meeting. Based on that contact, scheduling was again discussed in open session of the village board on May 20th. At that time, the hearing was adjourned to today's date, June 3rd. Notice of the hearing was mailed, as the administrator said, on May 21st. Certified return receipt requested. You brought a copy of the return receipt, Administrator? And what date is shown as the date of receipt?
5/23, May 23rd.
It's May 23rd. So not counting the date of receipts and the Memorial Day holiday, that's 6 business days prior to today's date that the notice was actually received by the appellant. The administrator's already gone through that. He was notified on May 30th that they would be unable to make today's hearing. So I don't think there's a question that the board could proceed tonight. Notice was properly given under our ordinance. There's been 2 hearing dates provided where the board was ready and willing to entertain evidence. Obviously, the best record that we could possibly put forward would require the appellant to be here and present evidence. But obviously, that's not going to occur this evening. So like I said, with that record before it, I think the board can either, by motion, proceed to conduct the hearing this evening, or if they're inclined, they can make a motion to adjourn to a future date.
We need to make a motion to
Proceed.
proceed.
Yeah, I'd like consensus from the board in the form of a formal motion if you're going to proceed this evening.
Motion to proceed with the hearing as is.
Second.
Okay, we have a motion and a second. Is there any comments? All in favor, say aye. Aye. Opposed? Okay, motion is hereby approved to proceed with the hearing.
All right, since the appellant is not present, I will note for the record that the appellant did submit to the village a number of written materials in support of their appeal. Those are included in the electronic packet for the board. The first is a letter dated January 13th, 2025, signed by Michael Heisey on behalf of Hawthorne Place. There's an enclosure of apparently the real estate tax bill for 2024. I believe that is the only written documentation submitted by the applicant in support of the appeal.
That's correct.
Is that correct,
That's
Administrator? All right, so again, with the applicant not present, that is the only information that the board can consider from the applicant's point of view, so I think we can consider that portion of the presentation closed. I will then turn to the administrator to make the presentation on behalf of the village's position.
Hawthorne Place LLC filed an appeal for the 2024 fire and EMS fees on January 13th, 2025. The property is physically located at 1105 Hawthorne Place, and for the record of this hearing, the tax ID number is PWV 0902996007. The property is owned residential multifamily. The ordinance, the fire and EMS fee ordinance, classifies this property as residential multifamily pursuant to the determination by the village board on May 21st, 2024, to reclassify their property when it was appealed for the 2023 fees. The ordinance, fire EMS fee ordinance, charges that classification 1 ESC per residential unit for residential multifamily. In 2024, the village charged 104 ESCs for 104 residential units, amounting to a total of $45,656. Upon receipt of this appeal, village staff confirmed that the arithmetic was correct and the property was charged appropriately.
And for the record, Administrator, you provided a copy of your written determination to the appellant, correct?
Correct.
Was that by letter dated February 5th of this year?
Yeah, that should be in the packet as well.
I believe it is.
Yeah.
Correct.
Are there any questions or comments by the board?
Seems as though the fee was applied as written.
So, any other information, Administrator?
No other information for me.
All right, so both sides having made their presentation, will declare the evidence portion closed. The board can now begin its deliberation.
My apologies. Seems the fee was applied as the ordinance is written.
Why was it reclassified?
It wasn't senior living, it's an over 55 community. We had different levels. Last year, for 2024, we had classified senior living and assisted living facilities differently, with a higher ESC. We revamped that in 2025. So in the 24 hearing, their argument was that they are not assisted living or senior, provide any level of care. They're just an over 55 residential apartment complex. So we reclassed them to align with the ordinance.
Got it.
In 24 based on residential units versus senior living units. And then we went away from that classification in 25 and went to what we have now. We don't have that separate classification. So that was the background on that.
And what was the basis of appeal by Mr. Heisey?
The original?
The 2024 appeal,
The,
or the appeal this year?
this year.
The current appeal? So the basis for his appeal is set forth in his letter dated January 13th, 2025. For purposes of completeness, it's rather succinct, so I will just read it. It reads, "Dear Clerk, Hawthorne Place is filing this appeal to contest the $45,656.90 fire and EMS fee imposed on its property as part of its 2024 real property tax bill attached. Hawthorne Place believes this fee is an illegal tax and violates Wisconsin Statute 70.11. Hawthorne further believes that Wisconsin Statute 66.0627 and 66.0628 does not give the Village of Pewaukee the authority to charge this fee, which they are relying on in order to impose such a fee. Thank you for your attention to this matter. I look forward to hearing from you." So that's the basis in the appellant's own words. What I would say is the legality of the fee is a determination that's already been made by this board in enacting the fee to begin with. The legality of the fee is subject to separate ongoing litigation, and it's not within the scope of the appeal process as set forth in our ordinance. So I would caution and recommend that any deliberation or discussion not even get into that question, because it's not within the scope of this appeal. It's a different matter for a different day.
In regards to the number of EFCs assigned being fair and EFCs being fair and reasonable in accordance with the ordinance, I think it is in this matter.
Would anyone be opposed to me making a motion? I'd make a motion to deny this appeal.
Second.
Okay, we have a motion and a second. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion is hereby carried. Mr. Attorney, are we okay?
We are, Mr. President. You can move on to the next agenda item.
Okay, then I'll move on. Hearing on an appeal of the 2024 Fire EMS Protection Field filed by KKNN Quail LLC CO Patrick Brotherhood regarding real property located at 1088 Quail Court and having tax ID number PWV 0903106 and possible action therein.
So this appeal is on a different track than the previous two. And by different track, I mean, while the previous two appeals or applicants did agree to waive the step in front of the Public Works and Safety Committee, this appellant did not. So a hearing, or excuse me, he did appear and the Public Works and Safety Committee did have a meeting and provide a recommendation on that. So I highlight that to state that this applicant is before the board for the first time in this posture. I will also represent to the board that I did receive a telephone call this afternoon from an attorney who has been retained by this applicant with regards to this appeal. The attorney did request an adjournment for some time for him to get up to speed. I told him that from our perspective, proper notice had been given. The board was in a position and posture to proceed this evening if they so chose. However, I did represent to him that my past recommendation in a similar circumstance for the other two applications was for the board to consider, and I think it would be reasonable for the board to consider one courtesy adjournment if one is so requested. So I told him I had made that recommendation in the past. I did not see a reason to depart from that in this instance. So I would make the same recommendation I did with regards to the previous two appeals, that a timely request for adjournment having been made, and this being the first one, in order to make a complete record that we are giving a fair opportunity for the appellant to be heard, I'd recommend the board would consider one courtesy adjournment.
Can I brief everyone on the event or what the evidence presented at the Public Works and Safety meeting was? Or what his stance, what the applicant's stance was?
Before we get into the merits of his appeal, which obviously he should have a chance to respond to if he so chooses, I think the board should make a determination on whether or not they'd be adjourning. Understanding your point that it may be relevant to the board's deliberation, but I think that's outweighed by the fact that he should be here if we're getting to the merits of his argument.
Can you clarify that I'm understanding you correctly, that regardless of the fact that we gave proper notice and followed the ordinance for this hearing, you still think it is, I forget the term you used, but the giving the most appropriate opportunity to do a complimentary?
Correct. I think the board has determined that 5 days business, or 5 business days notice, is a fair enough opportunity. What I'm saying is there's nothing that says you can't be even more fair and create a greater record that we've made every effort to allow this person to make an appeal and be heard. And if the choice is between giving that extra opportunity or proceeding on the first meeting, I would think that it's reasonable to at least consider giving one courtesy adjournment.
But didn't they already have one courtesy?
No, they did not.
This is a different one.
This is a different one. They have not had any.
Gotcha.
This is the first time they were appearing before this board.
Because
which
they
is why
didn't waive
The
their,
other two had the courtesy
but
adjournment.
because they didn't waive their part to the Public Works.
Correct. So part of it is me being consistent in what I recommended on the other two, being fair to all appellants, because this appellant's Quail Point is in the same posture that Hawthorne and Yankee were at the last meeting. They were unavailable. That was the first time they were appearing before the board, and my recommendation was to give them one courtesy adjournment.
I agree that we did kind of set precedents on that, but at the same time, he's not here because he retained legal counsel, which is his right to do. I'm not saying that he can't, but he also has been fully aware of this appeal process and knowing that a hearing is coming. So I think it's a little strange that he waited until the last minute and the last day to suddenly need a legal counsel. And now that legal counsel needs more time to come to get up to speed. Our meetings are also, just throwing it out there, I'm not saying that we don't give them the courtesy, but our meetings are live streamed and are out there. When people know that that this is on the agenda, that we're going to schedule a hearing, they've actually had 2 weeks' notice. I know it's not official, but they've had since our last meeting that we have scheduled these meetings. And if it's really that important to them, they would stay in tune to this and they would get this information sooner rather than later. So now I'm worried that we're going to set too much precedence, and this is going to be common, that they're just gonna wanna defer that first meeting to give them more time. So that's my take on it.
So they wrote January 8th. Is that correct? That they were starting this process? In the packet, I see January 8th. I don't know if that was the first one, but so 6 months ago, is that fair to say that they started the process 6 months ago?
Yep, that's correct.
That, I feel like the timing, you know, I also think there's an element of like respect of our time as well.
Well, I would guess coming out of the Public Works and Safety meeting, very much aware of what the next steps were.
You know it's coming. Right? Like,
Yeah, it was,
yeah.
village board was the next step.
Right. You can't be like, oh, I didn't know I was supposed to appear. Like, you knew the process was Public Works, Village Board.
When were they told from Public Works that this would be?
May 13th?
Well, so that's a good point. So if the administrator could just clarify for the record, when was notice of today's hearing provided to the appellant?
It was sent via certified mail on May 21st.
Did we receive a return receipt signed?
We did not receive a return receipt.
So we don't have a date of receipt in the record?
Correct.
Okay. So even if you give the,
Sorry, I have one more question.
Go ahead.
On the first round, when we deferred, was he on that agenda at that first time? The first scenario?
no, he was on the regular board to be scheduled. He was not on that agenda for hearing the appeal. So he was scheduled on May 20th. Notice was provided May 21st for the first time for this board.
I feel that if the reason for the inability to attend is because at this stage, he's secured counsel and not due to scheduling conflict or not being aware of the time frame, that feels less warranted, in my opinion.
Would it be wrong to assume that hiring counsel is preemptively selecting the next step of this process anyways?
So what I would say is he is involved in, this applicant is involved in other matters regarding the village, same topic, different matters, different litigation. He has other counsel for that. I am aware, and it's been represented to me, that this attorney has been retained solely for pursuit of this appeal.
I mean, I don't want to use the word bias, but I would say influenced in the fact that I've already heard his case once at the Public Works and Safety meeting. I'm aware of how that board ruled. I'm aware of how we left it with that applicant, knowing that if I was that applicant, I would be checking my emails daily to find out when this is getting scheduled, to take another bite at the apple. And to throw in the 25th hour a call from council to say, yeah, we're not gonna be there, I have to agree with some of the other statements that have been made that I can't find a reason to give an adjournment on this to hear it out. But that's, as I said, I've already had a crack at this one.
Is that confidential information?
That's why,
It's not confidential information, but it really should not, it gets into the merits of what he's arguing.
Right.
And determining whether or not to adjourn should not really be based on, I don't agree with,
Okay.
or agree with what he's saying, the merits of his argument. So rather than that decision be tainted, is the wrong word, but I'll use it, tainted by seeing or based on that, I'd rather the discussion just be, should we give him another chance or not?
but thus also following what Attorney Gerlinski has said, I am also a firm believer in the CYA in terms of when it comes down to it, do we do everything possible to cover ourselves so that it's all on the applicant? So however the rest of the board finds, I'm in agreement with it. But
Are those Public Works and Safety Committees, are they on YouTube?
They are not.
I didn't think so.
this one should have been.
I just have two things that I'll hang my hat on. One is that this is the first time the board is hearing it, and I have to agree with the attorney. We did give a slack on the other gentleman. I think it's only right that we do it here. And the second is, even though we did send a letter with return signature needed, we didn't get the return like the first one. The first one, I felt very comfortable voting the way we did because he did receive the letter and he had more than enough time. And this one, we don't know if he received the letter.
Can I ask, based on that though, isn't there tracking on these? Can you tell if it attempted delivery on them?
There should be a tracking.
I didn't mean to
There
interrupt
is.
President Knutson, but I think that can be an important point.
There is tracking. I don't know how accessible that information is to the administrator. at
You
this
just have
point
to
in
look it
time.
up on the UPS website, if there's a tracking code, and it should tell you attempted deliveries. So, because he could be declining, I mean, he could purposely be declining them. And I'm not saying that's the case, I'm making an assumption, but if, it's one thing if it got lost by the post office and it's held up, but if there was multiple attempts at delivery, I think that should be taken into consideration.
So, I mean, in my mind, I don't think the fact that we don't have a return receipt in the record, that does not obviate or negate the fact that proper service has been made. So I just want that to be clear, that we followed our ordinance, we provided notice 5 days prior to the hearing. So the fact that we don't have a return receipt, I know that gives us comfort and certainty as to when it was actually received, but the fact that we don't have it in the record does not necessarily mean we didn't follow our ordinance. So it's not a question in my mind, did we follow the 5 days? It's a question of, are we doing everything to provide a fair opportunity? I think another way to put it is the 5 days is satisfactory, it's allowable, but it's the minimum.
Well,
And I'm not advocating for him, I'm just
I would
I'm
disagree
just
with
trying to
that
be
statement.
consistent
I
in the
just wanna-
recommendation that I made to this board.
I would disagree that I think whatever we put into place, we would be putting out there to be fair and satisfactory, not bare minimum, for the record. But, do you want to say something?
No, go, please continue.
Can you refresh our memory, Attorney Glinsky, on if we proceed tonight, and then if we were to, like, what happens if, based on the two outcomes? If we find, based on our findings, like, what are their next steps, is what I'm trying to understand.
Their
Us
next,
delaying the hearing, what difference will that make in the outcome?
None really. I mean, anybody that's aggrieved by a decision of a governmental board always has the opportunity to appeal that to circuit court. So that would be their next step. Mr. McGaver in the audience, he's well aware of what's going on. He knows what that's all about. So that would be, in the event that the appellant continues to be aggrieved, that would be their next step, would be some sort of circuit court action. Josh Kanapaki from Kramer Malthof.
So what would the board like to do? Yes, I'm sorry, Bob.
In hearing the discussion, I agree with, I think that we have done everything that was required of us, but we're being given a recommendation from our legal expert saying that we should do this extra step. Isn't gonna hurt us. And because of that, I think I would recommend that we also delay this and have a special meeting or part of a regular meeting. Allow him to come back up.
To that point, and I don't want to interrupt, but I did confer with his counsel, and I let him know that the next two regularly scheduled board meetings are June 17th and July 1st, and the attorney is available for both of those dates.
Is or is not?
Is.
Then let's put it on the 17th.
Would it have to be a special one?
No.
Does not have to be.
I like the sound of that.
Is that your official recommendation?
My recommendation for a courtesy adjournment, yes, it's consistent with what I recommended on the other two. So I would make it for that reason.
Okay. Is everyone okay with the 5 o'clock on the 17th?
Nope, 6 o'clock.
6 o'clock.
It would be, I think the consensus was to put it on the regular agenda, not
Put it
any
on the
special.
regular agenda, okay.
So I'd like to make a motion to adjourn this meeting and reschedule it for June 17th.
This agenda item, right, specifically, or
At
does that?
6 o'clock.
As an agenda item.
This agenda item.
Adjourn this hearing to the regular meeting on June 17th.
Second, Grabowski.
Okay, we have a motion and a second. Any further discussion? All in favor, say aye.
Aye.
Aye. Opposed?
No.
Motion is hereby carried. Okay, next one up is, excuse me here. Well, discussion and possible action to set future meeting dates. Don't think we need to do that. We've already done that. Item 4 is adjournment.
Motion to adjourn.
Second.
All in favor, say aye.
Aye.
Aye. Opposed? We are hereby adjourned out of our special meeting.
Well, we can't get nice things.
Let's not like that when I hammer.
Just get that talent out of it.